Still Mr. Chief.
Habari yako? Issue of bail, bond, pending trial. The key question being whether there is any compelling reason why the accused person should not be released on bail or bond. The burden of proving existence of compelling reason lies upon the prosecution. Bail and bond policy guidelines provide at page 25 thereof as follows, and I quote, "The following procedures should apply to the bail hearing. A. The prosecution shall satisfy the court on a balance of probabilities of the existence of compelling reasons that justify denial of bail. The prosecution must therefore state the reasons that in its view should persuade the court to deny the accused person bail," unquote. The guidelines and provisions of Section 123 of the Criminal Procedure Code list what constitutes compelling reasons. While dealing with a question of what constitutes compelling reason, the High Court, in the case of Benjamin Jiru Bedan versus Republic 2021 EKLR, said as follows, and I quote, "The Court of Appeal in Michael Juma Oyamo and another versus Republic 2019 EKLR adopted the definition of the phrase compelling reason in the case of R versus Jackton, Malende and 3 others, where the learned judge held thus, quote, the phrase compelling reasons would denote reasons that are forceful and compelling and convincing, as to make the court feel very strongly that the accused should not be released on bond. Bail should not therefore be denied on flimsy grounds, but on real and cogent grounds that meet the high standards set by the Constitution," end of quotes. This is premised on the Constitution, on the presumption of innocence and the need to avoid pretrial detention except in deserving situations and cases. In the instant case, the prosecution submitted that the accused person is a flight risk and relied on the affidavit sworn by one Esther Buru on 13th January 2025. I have considered the oral submissions made by the prosecution counsel and the defense counsel and the views expressed by the counsel for the victim, and with respect I will not entirely reproduce the same in this ruling. The reasons for the submission that the accused person is a flight risk are, first, that upon receipt of the complaint, the investigating officer was not able to locate the accused person for a period of 1 month until he was arrested in respect of another case. Secondly, that the accused person had booked a flight out of Kenya to New York in the United States of America, which was scheduled for 13th January 2025, and that he is likely to abscond if released on bail or bond. Thirdly, that the accused has posted on a number of occasions in his Twitter account that he can relocate from Kenya, and there is therefore likelihood that he may abscond if granted bail or bond. The Twitter posts and electronic air ticket are both annexed to the aforesaid affidavit as annexures marked EM1 and EM2. The defense counsel, on their part, submitted that the accused person had booked the flight in the month of August 2024, even before the case was reported, that it is a return flight, excuse me, indicating that he intended to return back to the country, and that the case was reported on 11th of January 2025. I have looked at the annexures and the record. The air ticket aforesaid indicates that it is a return ticket issued on 10th of January 2025 and not August 2024 as submitted by the defense counsel. The occurrence book indicated on the face of the charge sheet indicates OB number 80/4/12/2024, a clear indication that the complaint to which this case relates was made or reported on 4th of December 2024 as submitted by the prosecution counsel, and not 11th of January 2025 as submitted by the defense counsel. What is on the face of the charge sheet is, however, subject to be established during the trial. What is clear, therefore, is that the submissions made by the defense counsel are not consistent with the documentation on record. What is not disputed is that the accused person had obtained an air travel itinerary in which he was scheduled to travel out of Kenya on 13th of January 2025 and to return on 20th ultimo. In the course of submissions, the court was shown the accused person's passport in support of submission that he is a business person who regularly travels out of the country and returns. Indeed, his passport shown to the court has several exit stamps and visas. Every application for bail or bond must be considered on the basis of its own peculiar facts and circumstances, as stated in the case of Twaiba Hashim Mutandia and 3 others versus Republic, 2014 EKLR. In this case, the accused person was scheduled to travel out of the country. He has previously traveled out of the country and returned several times, going by what is indicated in his passport. The submission that he has a large business interest in the country is not disputed. There is no allegation that by the time he was obtaining the air ticket to travel out of the country, he was aware that he was being sought by the police and therefore needed not to leave the country. The accused person is facing a charge of cheating, contrary to Section 315 of the Penal Code, which provides as follows, and I quote, "Any person who, by means of any fraudulent trick or device, obtains any other persons, obtains from any other person anything capable of being stolen, or induces any other person to deliver to any person anything capable of being stolen, or to pay or deliver to any person any money or goods or any greater sum of money or greater quantity of goods than you would have paid or delivered, but for such trick or device, is guilty of a misdemeanor and is liable to imprisonment for 3 years. The nature of the charge which the accused person is facing is a misdemeanor. I am unable to see a compelling reason why the accused person should not be granted bail or bond, because based on the foregoing, I am not convinced that the accused person is a flight risk. The particulars of offense, which are still subject to proof based on the presumption of innocence, indicate the value of the subject matter of the charge, which should be a consideration in determining bail or bond terms, taking into account the views of the victim's counsel also. The value of the subject matter is indicated as Kenya shillings 2,984,998. The defense counsel submitted that the accused person has business interest exceeding Kenya shillings 1 billion. Bail or bond terms should fit both the charge and the circumstances of an accused person, so that the same can truly be reasonable as required by the provisions of Article 49(1)(h) of the Constitution and Section 123 of the Criminal Procedure Code. Bail and bond terms should be that which an accused person can readily afford, and based on the foregoing reasons, based on the foregoing considerations, the accused person is granted cash bail of Kenya shillings 1 million with one contact person, and the accused shall not travel out of the country without prior notice and consent of the trial court, and his passport shall be deposited with the senior court administrator of this court, and the trial shall be fast-tracked. Orders accordingly. Of the application made in criminal case number E010 of 2025, that application has been determined and the terms have been set at cash bail of Kenya shillings 1 million with one contact person. Pre-trial mentioned on 28th of January this year.
Yes.
Yes.
That is fine. Appreciate it.
But now,
is there an alternative instead of cash bail as well?
oh, you want alternative bond? Okay.
We are hoping that, Your Honor, that it is only that 1 million, or is it in each file?
Yeah, the files are different.
Because I believe there was an intention to consult.
consolidate the two. Madam, is that? Pretrial mention of the accused is granted alternative bond of Kenya shillings 1 million with one surety of the same amount, and the bond terms shall be alternative to the cash bail terms granted. Parties to attempt an out-of-court settlement, and the court be updated on possibility of positive outcome on the next mentioned date of 28th of January this year. You're welcome.
In a case whereby there is a contract, and in a case whereby there is an agreement or a contract, it does not become a criminal case. It becomes a civil case. That's if the specifications have not been made, or the time has not been met, or any other agreement has not been reached. To try and turn out to make this a criminal case becomes the biggest problem. It includes pride. It includes lack of compassion. This is a matter that could have been sorted out. This is a matter that people could have sat. But when influence comes from the outside to ensure that a person who is emerging as a good businessman must be put down, that is where then we draw the line. The court, by its own wisdom, has realized that this is a matter that can be sorted out. Why did we have to rush to court initially? Why did we have to go to court? Why did we have to embarrass the young man? Why did you have to take him to court? Through this process. And then now, all over social media and everywhere else, oh, that gentleman, he was too proud, he was too what? That is not the issue. The issue is that this is a commercial transaction. It should have been sorted as such. If the ADR that the court has also realized can be effective is not done or is not reached, we will come back here. But in the meantime, as we were saying, we have also asked the DPP, and we are doing it formally as well, to relook into this file, because by their own standards and by their own measurements and by their own intelligence, they will realize that this is a matter that the police rushed too much. Because you see, they arrest the person on Saturday, and by Monday is in court. If they had consulted the DPP, would we be in court today? That is the question everybody needs to ask himself. Pride should not make us, because you feel like now you have reached a point where you can bring down a young man and you do not want to listen, and you bring pride. We will bring pride as well, because this is a case we can challenge, and this is a case we are certain we can beat.
Thank you so much.